Trustees meeting for Bartholomew Consolidated School Corporation. We'll start with roll call. We have in attendance Mr. Glick, Mr. Nowlin, Mr. Stenner, Mr. Major, Ms. Lloyd. We are expecting Ms. Wielden. She is not here yet. And on video, we have Mr. Schultz. Can you hear us, Mr. Schultz?
Yep.
Okay, great. And we can hear you. Thank you. Dr. Phillips, you want to run through the who and why?
Will do. Thank you. So this work session for this evening is focused on policy reviews. We put them in three different groups. The first group being the three policies that were pulled out of Package 5 that the board voted on at the August 11th meeting. Those are C475E, 125, and H100. And then the second group are the three that Mr. Schultz proposed amendments to, and those are A125, D150, and then I think actually B125 is inaccurate. The third one is the topic of committees. And we do have an existing board policy, which is B150, that includes committees, but the reference to it, I believe, is just one sentence. But you do have in front of you a document with descriptions of the changes and the comments from Mr. Schultz, as well as a few things that we were able to address during the course of the day today. And then the third group of policies is Policy Package 6 that will be on its first reading at the September 8th board meeting. And tonight, as usual, we have Mr. McIver here, the VCSE board attorney, and then joining him is Julia, and is it Kozicki from Church Hill and Antrim, that has, of course, been working with us on this policy consolidation and reorganization.
I think I saw an email that indicated that we might want to start the meeting with opportunity for public input. Is that so? If there's a member of the public that would like to address any of the policy considerations that are up tonight, I'd invite them to come to the podium. Seeing that there's no one, we can proceed with the agenda.
Thank you. So the first item is Policy C475, which is school-sponsored publications and productions. And in that policy, there is a prohibition against materials that are obscene, indecent, or vulgar. And there was a question from two different board members, Mr. Major back during the July board meeting, after that meeting, and then also from Mr. Schultz around that. The definition of obscene, indecent, or vulgar, and then also Mr. Major had asked about, is there a reason to, or is it logical to have the language mirror what we also consider inappropriate from a book curriculum material standpoint? Mr. McIver or Mrs. Kozicki, any input on those from a legal standpoint?
So your policy, thanks. The policy as drafted is reflecting how the Supreme Court has referred to obscene, indecent, or vulgar. I mean, we've drafted it mirroring Supreme Court opinions on the First Amendment over decades. Your library material policy, which may not be to you yet, but there was Indiana legislation in the last 2 years where the General Assembly has created a definition for obscene matter or performance. It is similar to, but not the same as, U.S. Supreme Court law. You can certainly choose to use the Indiana definition, or you can go with the slightly less defined obscene, indecent, or vulgar that the Supreme Court references. knowing that when the Supreme Court talks about obscene, indecent, or vulgar, they often say, you know, I know it when I see it is the classic phrase. So that would be a matter of discretion for the board versus the very specific Indiana definition. A matter or performance is obscene for the purposes of the article if the average person applying contemporary community standards finds the dominant theme of the matter or performance taken as a whole appeals to the prurient interest in sex. You might find indecent or vulgar extends beyond sex, but if you want to limit it to obscene, then you're pretty well limited to sex. So also that it would be lacking serious literary, artistic, political, or scientific value. So we'd be happy either way, but that gives you kind of a sense of, you know, what your options are as a board.
Just to summarize what I think our objective is this evening, and please jump in if I get this wrong, but we want to make sure that all of the board's questions about these policies are clarified. We don't want to come to any agreement on what the wording should be. Dr. Phillips, I suspect that you may want to make some changes based on what you hear, but so far you're bringing a recommendation to the board, and then the board is working with that recommendation. Is that the way we're going to continue?
That's correct. Okay. Thank you for the clarification there. After listening to the input and discussion from board members, we will either make adjustments to these draft policies that we will take again in front of you for a second reading at the September 8th board meeting, or we won't make changes and bring them to you for approval at the September 8th board meeting based on the discussion tonight. From our perspective, the same as Ms. Kazicki's, is that we do not have a strong feeling as administrative team either way, how it's defined in this policy versus the library materials policy. So I'm interested in discussion among board members as to whether or not the majority of you, I shouldn't say that, whether or not you, any of you have concerns about going one direction or the other.
Input from board members on this one?
Believe my notes may be what's in the Word document. And the reason I brought this up as a question is when you look at board governance, we should try to keep, and it kind of goes, it's kind of a common theme in multiple callouts, but we should attempt to keep the policies consistent regarding definition, regarding subject matter, depending on which party it is. So we've used the term obscene and the other one, and then we're going to use the same term obscene here, but it could mean something slightly different. And that's why I did ask the question. And so I don't know who spoke, but the lawyer that just recently spoke was like asking, I think my question more is around, do the students get the same privilege of lacking literary or educational value as the library materials, or do they not? Because my assumption would be is if we're going to put that as the bar here, we have to put that as the bar regardless of who the party is involved.
And I would say that just based on our past practice, and the items that have come to the board level from student publications, it would be that the board has chosen to apply that standard, the same standard as applies to the library materials, is that it has to lack value, overall artistic, political value.
Yeah, I mean, so in my opinion, then what I would say is that just needs to have that same caveat in that policy as it does in the other.
Any questions or concerns from any other board members?
I think another thing you and I talked about, Dr. Phillips, was with this policy, because somebody is going to be authoring something or designing something, who owns the copyright on the material that is created? Is it the author or is it the school corporation? Because it's not clearly defined here. And so I'm just trying to figure out who would own that.
I would assume it's publishing company, but
Well,
Typically, the school corporation be the publisher, so.
Yeah,
okay.
but it should be clear.
but does a publisher own a copyright, or does the author own the copyright? I was under the impression as soon as anybody wrote something of value, it became their copyright material until they gave that copyright authorization to someone else to then publish. So do we have a document that would tell, or in this policy, do we wish to describe how that copyright would be owned by the school corporation? That way we don't get challenged. And the reason why I'm saying this is if we had something that was creative enough, that was a slogan that a kid used, put on a t-shirt, the school sold t-shirts, made $5,000 and the kid wanted the $5,000. I'm just trying to figure out how to protect both sides here with something that is at least in writing enough that would describe to them that it does belong to the school corporation or to them.
That is a great question, and not one that I've had asked before with respect to this policy. So, not my immediate area of expertise, so we'll do some research.
And it's okay to not have an answer tonight. The reason why I ask is as an engineer, when I go to work, if I come up with a creative, novel concept that has not been done before, and I develop it for work, I can't then go take it outside for work and sell it. And so that's where I think I know when I sign an employment contract that I am agreeing to do that. So whether it's in the policy or if we figure out how to put it in an authorization form or something, I just want to make sure that all parties are protected.
And I would assume, Mr. Major, that doctrine that you're talking about is like works made for hire, and that's why you as an employee don't necessarily own that. And I would not assume that doctrine would apply for the student journalist at the student newspaper, because they're not in that same employee context.
Yep.
Other questions or comments on C 475?
Thank you. So the next policy in this group is E-125, promotion, placement, and retention of students. The proposed policy E-125 had a substantive difference from our existing policy in that it excluded all of those promotion, placement, retention, and grades of students from superintendent and board appeal. So a person who disagreed with a grade, a student being promoted to the next grade or retained in a current grade, could not appeal to the level of the superintendent or the board. That was a meaningful difference from the existing policy. And so we do not have opposition to striking that sentence that the board and/or superintendent shall not hear appeals or complaints regarding a student's grade or promotion/retention. Would be hesitant to add an additional clarification of an appeal or complaint process within other policies, because we currently have our public complaint policy in place, and just repeating that policy in different places is where we want to avoid it. That's where we are with our Neola policies now, where there are times, and you all have seen them, that language that was repeated in two different policies over the course of years came to conflict with one another. And so I would just want to refer to the existing policy on complaints in there if we wanted to address their ability to appeal a grade, promotion, or retention.
And I mean, again, I think it was my notes in there. I'm 100% aligned. I would rather refer to the other policy for consistency purposes. And then again, that just helps us as board members. If someone says, hey, I want you to do X, Y, when they're talking to me in public, it's like, here's the policy, here's where the chain of command is, here is where you follow, and just move through that process.
One thing I've noticed here is the use of the word, it's in the second paragraph, academic grades. And to me, that sounds like A, B, C. What was the grade for the coursework? And I think, Dr. Phillips, when you were talking about it, you were thinking second grade, third grade, fourth grade. So I wouldn't want, if there's a way to avoid it, I wouldn't want somebody coming to the school board to talk about whether they got an A or a B at the end of a course. But it does seem appropriate that they come to the school board to talk about whether or not they're being promoted or retained. Is that the way everybody understands this, academic grades versus promotion, retention?
The way I read it, when it said the determination of academic grades, then pause, and promotion or retention at a grade level, that's how I separated the two. So I looked at academic grades as ABC. To be honest with you, I think if you go through the teacher and a principal, that's where that part of it should stop. But having had a brother, my brother was held back in third grade, and I know there was a lot of discussion with my parents and lots of different people in the schools about why, right? And I think in his case, he had dyslexia, made sense. But there's other kids that the parents may not feel that holding them back is the best thing for them. And so I think that's where, to me, from a grades perspective, I think, 43% is a failing grade, for example. There's not much I think we're going to do to change a 43% grade. But if there's a kid that's at the edge of maybe needing to be held back, or maybe not quite ready for the next level, then I think if they want to challenge that all the way up to the board, I think the parents should be able to.
I interpreted Mr. Schultz as being both academic grades, as in the grade received on an assignment or in the course, and the placement grade of second grade, third grade, fourth grade.
My apologies. The way I read the policy, I thought it was talking like they're coming into the school system and you're slotting them, right? So that I think could be appealed. I don't think you should be able to appeal an A, B, C up to the school board. The way I understood it was slotting the child initially if they're new to the district, promotion, and restriction. So I interpreted it a totally different way, which means we may just need to clean up with the language if that's the case.
I think if you clean it up and you just make this be aligned to the normal complaint process, I think that clears it all up, at least in my opinion.
And I'm okay with the grades. Like, grade appeals should end to principals, like A, B, C, D appeals.
So if we don't want the grades to be part of an option for appeals, it seems like we need to separate them and do something different then. I mean, do you have to say that the grades would not be part of the appeals process, or do we just drop grades from this policy? But as it is right now, it certainly does mean academic grades, A, B, C, D, F, as well as promotion and retention.
Well, if you read the title, it says promotion, placement, and retention. So you could easily take grades out because grades don't fit with the title. And, then grades would just fit in the normal complaint process.
And in the conversations that we had following the last board meeting with Dr. Hack and Mr. Edwards and others, we have not had, an appeal of a student grade even come to the superintendent's desk in the amount of time that those folks have been in their roles and I've been in my role, and certainly not to the board level. And the board could certainly, if a person came and said, Mrs. Keel, I cannot believe you gave my child a B+ instead of an A-, and that appeal was filed to this level, the board could just send it back down and say, we're not hearing this appeal because it shouldn't be decided at the board level. Doesn't necessarily need to be in policy and hasn't been to this point, and it hasn't been a problem. Okay, I will move forward with E-125 based on the conversation and we'll send drafts of all these, out after we've made changes as well. There was also, Mr. Schultz had a comment, there was a inclusion in E-125 about sound principles of child guidance of the board discouraging the skipping of grades. And that's not in our policy now, so we don't have any opposition to removing that. We have had students skip grades. It is rare, and it involves really involved conversations with the family and the teachers and the principal to decide what is best for that child, but it has happened in the past. Okay, third on the list is high school visitors and parent and family engagement. And this is one that we struggle with around the recording of, if a parent or a visitor comes into the building and the policy states, the draft policy states that the person shall not record without getting permission first. And we understand that there's case law working its way through the courts, probably both at the state and the federal level, and lots of conversation around the right of a parent to be able to record a meeting. As a matter of fact, there is explicit language in special education law in the state of Indiana now that says a parent shall be able to record an IEP meeting. And so I think what we need is some language that differentiates between a parent who wants to record a meeting with a teacher or an administrator that's about their individual child or children from a visitor or a parent who comes into the building and uses their phone to record day-to-day student interactions, or wants to record a teacher teaching in their classroom with all kinds of other students in there that aren't their child. So I think if there's language that differentiates those two, we could be comfortable, at least from an administration standpoint, with differentiating between those two. We just need some help from the attorneys if, in fact, the board members feel the same about needing to differentiate between those two.
I thought, Mike, your interpretation was that the language as it stands today was pretty clear and that we didn't need further language. So I don't know if we're making a problem where there's not a problem. I don't know if we should change anything if you feel like we're covered with the situations that were described.
So the policy as currently drafted focuses on school visitors, and that is defined. And then you talk about, because I know Mr. Major had a question, I think, about like even online versus in person at the board meeting. And if you look at some of the language, it is more specific to classroom type settings there. I guess so I read it that way as a visitor policy. I think the only question is if you all have a board of 7 people and if multiple members of this board read it differently or have confusion, then I think the question would be, do you feel like that needs any more of a call out along the lines of what Dr. Phillips is suggesting? But I would tell you that as I look at it today, to me it is a policy intended to be aimed at visitors, because when you think about the school space, the space beyond the front door, even though we talk about it being a public building, right, that's not a public space that somebody can just go into off the street without checking in and can do whatever they want. There is the ability to have rules there and have some restrictions in place on what can happen. And so from that standpoint, when I think about a traditional visitor, to me the policy makes sense as a visitor policy. But if there's confusion when people are reading it, perhaps that may be where you want some of those clarifications.
Okay.
Yeah, and based on what you said last time, I put more thought into it, and I was thinking, you're not going to have visitors in schools every day. Like most of us are not going to just walk into a school and say, I want to go watch Billy Joe Bob in this class. You might go into a school and say, hey, my nephew or niece or son or daughter or grandchild is doing their senior project, and I want to go in and watch them do that, right? And that's more, I think, of an open invitation from the principals to the families to be able to participate in that because it's significant to their graduation. So for me, I felt a lot better after we talked last time, this being just for visitors. Visitors are going to be mostly restricted. They're not going to just be able to walk into a classroom. And their presence will be known by many people and why they're supposed to be there. So I felt like there wouldn't be as much risk then to a teacher having a concern that they were videotaped or they were recorded and put all over the internet for the world to see, so.
But I think as it stands today, they would have to have explicit permission, which is what we want, which is what I want. I shouldn't generalize. I want a person to have to ask permission to video record anything in the classroom as a visitor basis.
Yep.
And that's how it's written, and that's, I think, how Mike interpreted it, and I did the same. So I don't know that we need a change, and I think you are agreeing. I just wanted to clarify.
Yeah, I am agreeing.
Okay.
And I think that it says the principal and instructor must give approval. Now, that's in our policy, but the law is the law, so there's trick to that, right? I mean, we have to control it the best we can and hope that nobody's going to do anything wrong.
So if we leave this policy like it is, and the state says parents can record IEP meetings, are we in compliance with that, the way it's written? And my other comment here is, it seems like things really fall into three categories. There's the classroom, there's meetings like IEP meetings, but there's also hallways and cafeterias that when we say instruction, I don't know that that includes that.
Yeah, and I struggle. So last year I saw a video of a teacher walking a kid to the principal's office that was shared on Facebook. And, you know, there's a violation there, right? I mean, the kid's using a phone in school.
Right, which is probably another kid.
So I think we should hopefully have enough other mechanisms that keep people honest. And, you know, and there's always going to be cases where people are going to try and skirt the system. But I think Dr. Phillips already mentioned that, you know, it either is or on its way to being law for IEPs to be able to be monitored and recorded. And if we need to add that, then we can, but law's the law too, so law
It's
supersedes
included,
policy.
it's already reflected in our special education policy.
And there is a different policy that may not have made it to your board yet, G350, that talks specifically about parents' ability to record IEPs, audio, video, and digital recording on school property and of school meetings. And there's a new statute in Indiana that just came out that made explicit that parents are entitled to record IEP meetings. So that's separate from H100, which again is really focused on visitors more than it is parents and family members.
Is that in our next unit or the one after? Do you remember?
Looking at the batches that I received, I don't know if it's been sent to you yet, but I can see it in the folder, so
I think
it's
it's in
coming.
it's in the last group, I believe.
Okay.
You said 350, G350?
G350 is probably your last batch.
It'll be in the last batch. Yeah.
Okay,
Got
thank
it.
you.
So not this one, but the
Previews of coming attractions.
Is that batch 17?
That we-
last
One
one, the
number is
final.
the last
But
batch.
that we hope to get to within the next 3 months, right? We are hoping to finish all of this very quickly, so we're just in that messy middle.
Indeed.
Understood.
So then,
So oh my bad, you're good, Del.
in terms of recording cafeteria or cafeteria, I think would fall under services, the way we have it worded, but, and hallways, the state counts passing period as instructional time still, I think. So is that included? Do we need to say anything beyond that to cover everything beyond the office like we talked about?
So I guess my question is, are you hoping to prevent recording or?
Like,
in the
prevent
hallway?
recordings without permission
Right.
from parents. I don't know if we can control it from kids.
And that's the thing. And again, you know, the likelihood you're going to have an unescorted parent in the building during the day recording something. Under H100, if they are a visitor, going to that language again. Right. They should not be recording.
Okay.
Quick question. If we allow them visitation to the facility, and we even have this policy in place as it is written today, can you hold them accountable given the one-party consent of Indiana state law? Let's say, for example, you let XYZ visitor in for training or whatever, and they record the whole thing and they have their phone in their pocket, all the audio's there. There's no crime because it's still under one-party consent. So really, in reality, I guess what I'm trying to understand is you've invited them in. The one-party consent doesn't end at the door. And you have no way, like, it's a policy that it has a bark, but it has no bite, I guess is what I'm trying to understand.
I think, as always, Logan, the devil would be in the details, right? Because to me, one-party consent implies a conversation. I think that's what that standard is applicable to. Voyeurism is illegal in Indiana, right? You know, recording in certain situations without the other person knowing is against the law. And so I think a person walking through the hallway, the cafeteria, the gym, into a classroom, I don't know that they can say one-party consent because I knew I was recording even though nobody else did. So I think if it was a sit-down meeting, and if they were recording that meeting and they were truly a participant, then I think, you know, we would probably have a hard time restricting them from that. But I don't think that's what our policy is collectively between this one and the other one. I don't think that's what we're going to be after anyway.
So an example, right, is so like Mr. Bennett has spoken publicly 2 or 3 times about school safety. Let's say one of the principals invites him in to walk through and help provide feedback on school safety. And he were to tape that conversation. That is a visitor. That is a sit-down meeting. The policy may sit there, but I believe one-party consent will still hold.
Depending on what he records, I mean, the purpose of the policy in part is protecting the privacy rights of students. So
Correct.
if I'm
Agreed. I hear you on that. I'm talking about like like there's 1 or 2 adults with the visitor.
and
I
we
think
would
we
expect-
want to try to write a policy that meets the spirit of what we would like to see from adults, visitors in the building, which is that they need to get consent. And I think you're kind of on the fringes, Logan, thinking about these, you know, kind of way off scenarios that I don't know if that's what we're trying to make the policy do. We're trying to document what our expectations are. The question of enforceability and the amount of resources or energy we would put into that is probably a separate conversation. Are we aligned, though, that we would want them to ask permission of an administrator and somebody else? If we are, I think we just need to move on in the interest of making sure we get to the other items. Because I think this is a circular reference. Like, I don't know if we're going to get out of this because we would each have our...
As a board, we're expected to draft policies in the spirit of the law, too.
Yeah.
Right? So, like, that's the thing. Is like, I'm asking, if it's in contrast to the law, then I have questions. If it is not, then I do not. Because I agree with you. In spirit, I want them to seek permission. But I don't want to put the board or the school corporation in a situation where you're drafting policies contrary to law.
I wouldn't say
So,
it's, I don't know that it's contrary to law to say our expectation is that we need to respect the rights of privacy of our students because we're not going to let people randomly record as they walk through the hallways. So that's setting the expectation. We understand that Indiana might permit you to record, but we're going to tell you our expectation is because we have obligations to protect the privacy of our students, we're going to ask that you not record, even though you might be permitted to do so under Indiana statute. That's how I would interpret.
that's perfectly understandable. I just question the word shall, but okay.
Thank you very much. On the second part of that policy, there was a concern about the requirement to communicate first with the superintendent if under the term visitor, I think they were including board members in this language. That if a board member observes a situation or condition which causes concern, the board member should discuss the situation first with the superintendent as soon as convenient or appropriate. Because again, this is actually already covered in D175, board staff communication. I'm perfectly content with striking it from H100 because it's covered by that existing policy already. Any other questions or concerns on H100?
I have a question unrelated to what we just discussed. I know that the sex offender registry and violent offender registry is leveraged upon visitors, but what do schools currently do for NCOs and protective orders?
We call Mr. MacGyver and ask for his guidance almost every time. I say that, almost flippantly, but
Because those
in
aren't, those
almost
wouldn't
every
populate
case,
in safe visitor.
I'm going to say in every case, when we have a situation where there's a no contact order or restraining, we are talking to Mr. MacGyver and making sure that we're navigating that, or to, another attorney that works with us as well.
You document those in student files?
To the extent that we're allowed to by law, yes. Okay, thank you. The next group of three policies are related to the proposals that Mr. Schultz shared prior to the board meeting on August 11th. And so I can go through them, or Mr. Schultz, if you wanted to give a high-level view of each one of them. Everyone has them in front of them as well.
Okay.
And they received
The
what we
first,
sent
the
on
first one, go ahead. What?
Go ahead.
Apologies, Chad. The first one I sent, which is A125, how I read it, and I asked for some legal questions, so there may be some other feedback that I've not seen yet, but it seems that it restricts the conflict of interest of deriving a financial benefit from the contract in which you are voting on, rather than political and or financial benefit from prior to or from a direct result of that contract. And so cleaning up that language to protect against essentially situations where one may give a gift in which one is hoping to win political favor over, and then in result receive a vote in favor of themselves to that point. And so that's the cleanup of A125.
I think I'd like you to be more specific on what you're trying to get at with this, because I believe you have a very specific situation that you're referring to, and I think that we need to understand the root of it to have the right words in the document.
So, and I actually gave a couple questions in the email to Dr. Phillips. So a good example is right now, last month, we voted on Maple Grove Elementary. If Pepper Construction gave me $2,000 in my campaign, could I in good faith vote without a conflict of interest on that within the policy as it's written today? That was the question I asked. How I read it, I don't have to have a conflict of interest, and I could vote on it. But if it's read differently, then that's misinterpretation on my side.
I don't think that's exactly the situation that drove this language, though, Logan. Can you maybe back up another step? What drove this language?
That's the example that I'm giving, yes.
But what was the example that drove this language initially right before our last school board meeting?
I'm not following. I mean, it's regardless of any specific situation. They all apply equally.
I don't know that they do. I don't know why you're not sharing, but I can share on your behalf if you would like me to. I think what you are worried about is that in elections that some board members could be supported by a PAC.
Yep.
And that PAC was supported by teachers, maybe in the district, maybe out of the district, and because that teacher PAC was supporting a board member that they could not participate in any activities related to things that could financially benefit teachers.
I would say
Is
that would
that
have
the
fallen.
specific example that you gave? And I think it was specifically targeted to a couple of us who did receive very publicly, which was disclosed appropriately in our financial statements. I think the question that I have is, in every election, you're likely going to have a teachers association who's very invested and who ends up on a board either being for or against a slate of candidates. And so you're automatically, I'm a little worried about where this is going, because you're gonna cut out half of a board potentially because they weren't who the teachers of Indiana, as the example that you gave when you drafted this language, supported. So I think that, I'm trying to play that out and understand where that could lead us.
But can I say something here real quick?
Go for it, Tom.
Yeah. I think the conflict of interest goes a little bit deeper than just the necessary PAC financial support, because part of the PAC membership has representation from the teachers union. There's a person on the board for the teachers union who also sits on the PAC board. And then on top of that, to see the flow of money or where it went is kind of what he's hinting at, in terms of all the money from the PAC went to another member of the union's family business. That's kind of where the workaround is in terms of a conflict of interest. And if you don't see it, either you have blinders on, or maybe you don't understand conflict of interest. I don't know.
And I kind of want to pause there, right? Is I agree that's a core of this one situation. But if you don't put a stop on quid pro quo, I can take out IPACE and CEA and put in Pepper and the Indiana General Constructors PAC. And it's basically open season on board members of giving money to receive feedback or to receive positive light. And again, I'm not a fan of lobbying. I see it in the Congress in DC. Not a fan of lobbying at all. I prefer it to be totally gone. I don't know if I want to see lobbying at a school board level. And so that's where this gets that out of it. You can't receive it and vote for it. I mean, and again, right, we've set a precedence at BCSC of holding a high bar. I believe both Mr. Major and Ms. Wilden had a one-time conflict of interest on a minor few engines for buses, which is a few very minor detail over versus this. And when we start having candidates, in this case, because you brought it up with the political candidates, we have candidates that received more than 85% of their funds and money funneling back to relatives, businesses of the teachers union leadership team. I have received questions, and I think they are valid questions of what is the term of conflict of interest at that point.
What's the family business of?
I think what he's saying, I don't know why we're being so evasive on all of this. I think it's because Tony London Company has provided printing services to several candidates during campaigns, and he's drawing the tie to that printing service and the CEA president, and furthering the conflict of interest kind of string.
He also friends with the GOP that Jason's a leader of. I mean, how's that?
I tend to agree. I'm not sure where we're going with this. I did want to ask specifically that we crossed out financially multiple times in here. I think just leaving the word benefit is a little nebulous, and if we're going back to our enforcement tangent on the last conversation, feels like it's taking a step backwards, but I didn't know if you had something specific in mind with crossing that out.
Logan, hey, I think,
One
Logan.
second. But okay, give me 1 second. But she just said that. I hear you, right? Nikki, we just said enforcement. But on the last one, we said, what is the spirit of what we want to do? In the spirit, I would not want to see board members benefit financially, politically, or any other benefit from a course of their vote. So if we want to go with that, like if that's the way we're building policy, then the spirit, I would say benefit. If enforcement, I would say politically and or financially.
Like, if somebody buys a person a coffee, is that benefiting?
I
Is
think we
that,
both
I
could say-
think that's
I think
where,
we
Is
can
it-
both
well, I
say-
think
so
the
you're-
coffee thing becomes, is it a gift? If it's a gift, you have to claim it. So I think there's a whole lot of law there that hopefully all of the candidates have read and understood enough so that they don't get called to the carpet someday because they've misrepresented themselves on their CFA 4s. But I think the concern here, yes, I am the secretary of the Bartholomew County Republican Party. Have I purchased or have I directed anyone to purchase anything from Tony London? No. Matter of fact, I paid for the yardsticks and the bracelets that we gave out of my own money, bought them from imprint.com, and specifically told the other leaders that I was not going to purchase anything from Tony because of that. So I have protected myself. I think in this case, the concern I think that's been noted that the three of us have talked about is the fact that there's people that gathered almost $3,000 a person from iPace, which was recommended by CEA. That money did go back to Tony London Company, but well beyond that, because I think you all each supported them with around $4,000 worth of materials. And then I think the concern that I had, which just made me furious a couple months ago, was when we were talking about the lunches for kids, and Amy came in and said, we have a lot more other important things to spend our money on at this time. And everybody immediately, there was a no vote right after that. So
I was
so
a no
think
vote before that, Jason.
I think the perception is what I think is important here with conflict of interest, is what would the average individual think was happening with this, and I think that's where the concern is. When you see this, it sure feels like pay to play. Whether it is or not, I don't know. I don't make your decisions for you, but I think the average person would see you get an endorsement, which should be I'm fine with an endorsement and getting backing, but when you get money and then turn around and give money back to the same people that endorsed you, that's just, I think, something that is just not cool. And that's why I think we need to make this a little bit more robust with the conflict of interest and make sure people know what makes sense. I defer to lawyers. I mean, the lawyers are going to know this law better than we will.
In my opinion is, and that's why I tried to use the other examples, right? There's a lot of emotional attachment to using CEA and teachers union. So my opinion would be, if you insert Pepper Construction and the Indiana General Constructors PAC, which is available, are we still without a conflict of interest from a legal standpoint? And I just don't agree with that. And so by de facto, it applies across as well. Taking the emotion of the teacher out, the process should be the same, regardless if it's a lobbying group of teachers or if it's a lobbying group of general contractors.
I guess, since we've asked for legal advice, I think the legal question would be, is there a legal violation of conflict of interest in the example that was given? And just so we can understand if there's anything that needs to be changed. Because I think we also have a conflict of interest process that I did not fill out because I didn't see it as such. But if that was amiss, that's something I need to work on.
There is a state statute that defines conflict of interest for purposes of elected officials. And so when we have had discussions in the past and a board member has said, is XYZ a conflict of interest? Many times you will hear me say, it is not a technical conflict of interest. The reason that I say that many of the times is because if you go back and look at that statute, it very clearly states that a conflict is when that elected official has not done a disclosure, and if they have a pecuniary interest in a contract or a purchase. That phrase, pecuniary interest, is very specifically defined in the statute It is something that results or is intended to result in an ascertainable increase in the income or net worth of the public servant. And so to Logan's question or hypothetical of Pepper, if Pepper Construction made a donation, I likely would tell you that that is not technically a conflict, because my assumption is that they did not make a donation to Logan Schultz. They made a donation to the Friends of Logan Schultz Political Committee, which is different. If they write a check to a board member and that check goes into his individual account and then he approves the contract, okay, right, discussion of bribery at that point. But political support is typically going to be separate. Likewise, if it is a PAC that donates to a school board member, a state legislator, a member of Congress, whoever it may be, generally speaking, that's probably not going to be a conflict. It is not, if that donation is routed appropriately to an election committee, if it is reported appropriately by the election committee, it likely does not technically violate those statutes. That would be the standard. And so I think if I hear Mr. Schultz, he is saying, I think we should hold ourselves to a higher standard than the standards. And I think that's conversation for you all to have, but at least as that technical definition of a conflict of interest under the Indiana Code, an ascertainable increase in the income or net worth of that public servant based on approval of that contract. And I don't know that most appropriate donations to a political election campaign are likely going to trigger that. If they were, the state reps wouldn't be able to vote on anything. I mean,
Right.
But, and that's what I'm asking, Mr. McIver, because we discussed this at one time, and I think you even said, not a technical conflict of interest, but I would still advise you as a conflict of interest under B100, which is board members should avoid even the appearance of impropriety, right? And this is where you're now not in the law of Indiana, you're in the law of public.
And that is your current language in one of the policies about avoiding the appearance of impropriety. And so, again, I think there is a question of appropriate political donations made through the appropriate process and whether that does constitute an appearance of impropriety or not. But that is language that Mr. Schultz is accurately referring to in the policies.
Yeah. Okay.
I guess.
I don't know where to go from here. I personally don't support crossing out financially, and I don't know if I agree with anything in green, frankly.
And I guess.
However, go ahead.
One last comment, I would say, at least, and I will let Julia chime in if she has anything she wants to say, but my perspective would be that the draft policy as proposed is consistent with the conflict of interest statute in the state statutes, because that is why I'm sure that word financial is in there. That's in there is it's a slightly easier to understand way of this pecuniary interest test that's built in there. So I guess my opinion would be the policy follows the statute. Where you all go beyond that is up to you.
And that aligns with what I would say is, the purpose of A125 is to lay out what your baseline is for conflicts of interest in alignment with the statute. If under B100 you feel like you want to be more transparent, that is certainly your choice as a board member. But this is setting your statutory requirement for disclosing conflicts of interest in alignment with the form that you all had to fill out after you were elected and submit to the state on what conflicts you have. So, which refers to the same pecuniary interest requirement that Mike has already talked about. So those are all within alignment. The H125 aligns with the conflict of interest form, aligns with the statute. B100, you can hold yourselves to a higher standard if you like, but this is trying to be in alignment with the statute.
Understand.
So is it my understanding that we can't have both then? I mean, we can't we can't say we're holding ourselves to not even the appearance of impropriety, while also keeping a door that has now led to substacks and columns being written indicating as such.
I would like to say that's almost conflicting.
Yeah.
You're thinking, like, just because the verbiage in here says one thing and another piece says another, doesn't mean that we cannot hold ourselves to a higher standard. Like, don't get wrapped up in the language. Actions speak louder than words. So I think we may be getting hung up on this a little too much.
I guess I've heard you say that B100 and maybe even the board ethics policy is a place for us to look for some language to help address the concerns that what we have today in this policy does meet statute.
I guess the only thing that I would point out to you is that I think that is an appropriate place for you all
Spend some time.
to put that on there. However, you may have instances where you have a completely open seat that multiple candidates are running for who are not board members. You may have someone running for a seat who's not a board member, and whatever policies you may have, at the end of the day, from a true standpoint, the definition in the statute is what's going to determine if it's a conflict of interest that's actionable, under the law. You can put some of these aspirational things in there, but there may be situations when they don't apply, or, little else happens as a result of it.
I think we need to hear from other board members on this topic so we can understand how people are thinking about this policy and the changes provided. Only a few of us have talked. Can I ask my vice president over there to say something?
Sure, I think
See what's on your mind.
all my questions have been answered, and I'm ready for the administration's proposal. I'm sorry, for this section, A125, D150, and maybe B150, were these amendments introduced in a board meeting? Or these are amendments that might be introduced in a board meeting?
They were emailed to you ahead of the board meeting and attempted to be put in, but were declined.
Okay.
This was a few hours ahead of the board meeting last meeting, Rich.
So I guess I have one question of what I think I might not understand. So the way we have been operating with conflicts of interest, just as an example, if you work for Cummins, you fill out a conflict of interest thing, and if something comes up in a vote, I think that then you would recuse yourself from that vote. So if I apply this here, you're saying if someone receives a political contribution in the campaign from the teachers union, then anything that impacts the teachers, you would have to recuse yourself?
No, that's not what I'm saying. I am saying that you draw personally, let's talk about in the case of you, a larger financial and or political benefit that is a higher level of conflict of interest than, say, Jason when he worked for Cummins, when he signed the conflict of interest form for 12 engines on a revenue of $45 billion at the time it was, right? And so that's what I'm saying is when you're into contracts, you have received a higher political contribution or a higher political benefit, which states a higher level of conflict of interest regarding contracts, not anything.
I don't know. It's a path that I would not advise that we would go down.
Whitney, do you have anything to share on this? Because I think we need to give enough commentary so that Dr. Phillips can make a recommendation for our next meeting agenda and such.
I do, I'm having trouble putting them all in order. Yeah. I'm just shocked that people think that of other people, but I don't know, maybe I'm naive. I also think it's a slippery slope, and as hostile as this board is, I question what will be weaponized and what won't.
Please say more.
I think we'll just move on.
I just, like you
think-
say,
Well,
weaponized.
Logan,
Hold on.
Logan says contracts. I highly doubt it stops there.
Well, I guess when you say weaponize, there's always going to be a 4-3 vote.
I don't
Always
believe
going to
that.
be at least a 4-3 vote, always, at least. So when you say weaponize, for Tom, Logan, and I, who are in the minority here, how can we weaponize anything against you guys if you guys will just either not vote for it, not hear it, or not put it on an agenda? So I want to understand, when you say weaponize, please help me understand what that means.
I disagree that it will always be 4-3. I hope that we can get to a place where that's not the case. It makes me sad to hear you say that.
I feel like we've gotten off track, and we need to stay focused, and this may be something that needs to be off and individually spoken with and not here. We need to reconvene on what is important and what we came here to do.
Yep,
Otherwise, we're wasting our time.
I agree. I also think that maybe where some of the issue is, and I put it on the table, so I'll think long and hard about whether that was the right thing to do or not, but I generally feel like we do need to work better together as a team, and I have voted with the under the 3 before. In fact, I did it last meeting.
Me too.
I guess I'm just, guys, the public is expecting something from this team, and we need to act in accordance. And I guess I would just say that what could have happened in this, conflict, somebody could have just called Nikki Wielden and said, look, there are people that are seeing something a certain way, and we'd like you to reconsider whether you're the right person to be on that committee. And then maybe I would have just said, you're right. And there's other qualified people, and I don't want that perception to be there. And we don't have to do this really messy policy thing as a team. I just think that we would do ourselves a favor to try to work some things in the background a little more effectively through conversation. And I'm open to that. And if I've given the impression I am not, I'm sorry for that. But I'm worried we're making some of these things really hard, and it's got to be leaving people with a poor impression of the collective sitting here today. And it's disappointing to me, because I think we all want to set a good example and are here for a good reason.
I hear you. I will say I'm equally frustrated, right? Because there's a lot of actions done. We always say we want to have this done through a phone call. The government should act in front of the people and see what is being done in the best interest of the taxpayers and the people. And I hear you, but in a good example, we're going to go right into the next policy. I would agree there could be a chance of no conflict of interest if a decision isn't made within an executive committee without board input, an appointment. And then that's where it gets into where maybe there is. And I think that's where we got to have those conversations and say, if we're going to do it, then the executive committee, when they make decisions, has to reach out and collect input before they run with those decisions. Because I didn't get a chance for input. I mean, I don't know, Jason or Tom, if you got called, but I didn't get any feedback in regards to the appointment at that point that you're referring to, which is referring to you, I'm assuming, on the collective bargaining.
I do, I think the thing I took away from your comments on this topic, the committee appointments should probably have the bargaining committee leader, like that during that restructuring meeting at the beginning of the year where we have the list of committees, it's probably appropriate for us to add that to the list and be handled during the normal reorganization meeting. I think that's where the miss was. I think I missed it because it's always been the board president since I've been here, so it didn't occur to me that it would be any different, and I think this made me think differently about having it added to that list. And then we would ask others, just like we normally do as a team, who would like to participate, and we would try to go through that process ahead of the restructuring meeting.
I'm not saying just that, right? So if you go in the letter and you go to the bottom, it says anybody who's put into that should come to the board for approval. Whether that's going to be a 7-0 vote, whether it's not, I don't know. But like, we can do that now. But we're choosing not to. And I hear you, like, we could put it on there and get feedback, but like, and I don't know how all the committees is slated out, but you know, just because you ask us what we want to be on doesn't mean that we don't give feedback that is good quality of others that could be or could not be better. And so that's what I'm saying is, like, we're choosing now not to do it, even though we have a board meeting ahead of us before to do it. So it's, you can say it out on one side, but you can't say it out both. That's where I'm getting conflict is like, as a board, I want to work across the aisle. I just had a meeting with Dale talking about referendum, and like I want to work across, but like when it happens in this bubble and then there's no conversation, it's like, please call me. Like I don't want to talk. You know, let's talk. Let's not email. Let's not have any written record of that. And then we go in and say, but we want to do this. Don't talk about it. You can't have it. That's not working in front of the people that elected us. And like they're going to want to know, like, are we appointing someone with a potential conflict of interest? Call it, vote on it. At least then the public knows. There is nothing that is wrong when you give full transparency. A vote is full transparency regardless of the committee appointment. We voted to put Dale and I on the engagement committee. I think we voted to put Jason and Pat or Rich, I can't remember, on the committee around redoing the agenda of our meetings. I can't believe that the collective bargaining is of less importance than those extra committees that we had created.
Logan, I think we need to move on, buddy. Like,
yep.
We're circling and beating a dead horse right now. Next slide.
Nothing. Go on.
That's it.
Do so. Okay, the next item on the list is D-150, Board Superintendent Relationship. And there was just a clarification to be added there that the superintendent appoints the members of the negotiating team. That was the original language in this policy, but Mr. Schultz pointed out that that should be non-board members of the negotiation team, and that's been the case always in the past, and so we have no opposition to having that reflected. Any questions or concerns on D-150, including non-board? Okay. And then the third one, Logan, the language that you sent us a couple of weeks ago was from, I believe, from Neola's policy 0155 with some modifications. And then I just noted that committees are part of B-150 now. It's just a one-sentence statement in there about committees, though. So I'm not sure if the board wants to, in that conversation about appointing committees, my preference would be to modify B-150, obviously, since that's our newly adopted policy.
So what, if you did modify B-150, or you suggested that we modify B-150, where would you make that change?
We would simply add to the statement that the board approves committee members, that the sentence in green at the bottom that you know, the president can assign a member of a committee in case of emergency. Otherwise, the board approves all committee appointments. Something to that effect. Is that an accurate representation of your position, Logan?
Yeah. I apologize. They're both currently active on the system, so I saw 155 on there as well, so that was why I was confused.
And I looked this morning, I could not find it for the life of me, so you could be right, and I missed it. But either way, it's just to clarify
fine.
the fact that the board approves all committee appointments unless there's an emergency. Any questions or concerns in regards to B-150 adding a statement the board will approve those committee appointments unless there's an emergency?
I'll leave it to you all to work out, but I would suggest that there might be a better word than nominated. Maybe proposed, or maybe nominated's the right word, but it just seems odd in that sentence to me. So I'd ask you to think about that word.
Thank you. Okay, we're through 6 and 14 to go. But these 14 are none that, at least for the most part, have had any questions, some of which we were able to address. Mr. Schultz sent some questions yesterday, and so some of those we were able to address today. I'll go down through these, just even the ones that haven't had any questions sent to us yet, and just make sure, pause for a moment to make sure no one has any questions on them. The first one being D-275, drug-free workplace. Again, these are the next package that will be on a first reading on September 8th. So questions about D-275, drug-free workplace? And then also D-350, fitness for duty, leaves and examinations.
Towards the end, there's a longer paragraph. In that paragraph that starts in agreeing to perform, if you go down about 5 rows, it says something about genetic information, non-discrimination, and then it says, and relevant board policy. I was hoping we could put what that policy is, rather than have people try and figure out what the policy should be. If we could just define what that is and put that number there. And if it's one we don't have yet, could we introduce that one with this one so that we put them through both at the same time?
Thank you. And I forgot that you had asked that question about the genetic information.
Well, that was on a different one. The genetic information one, that's not what my worry is. It's just the relevant policy part. I asked about genetic information in a different policy, so.
Are we on D-350 now?
You're on D-350.
Thank you.
Could you point out again to me one more time?
After the words where it says GINA in parentheses, so it's the last long paragraph on page 1. And it says, in compliance with the Genetic Information Non-Discrimination Act, GINA, and relevant board policy. If we could put the policy number in.
Gotcha. Sorry, it took me forever to find it.
If there are multiple, can we put them down below? That way it's not like, because I assume we've left it broad because there are multiple that may associate to that.
Thank you. We'll follow up with the church team on that clarification. Thank you.
Just reduce clutter as much as possible.
Yes, thanks. Agreed. Next policy was D-375, employee discipline. And there was one question about the employee having the right to appeal the decision of a suspension by the superintendent. And the answer to that is yes. And it comes there in the second to last sentence, which states that any suspension of an employee shall comply with applicable due process requirements. And so, as has happened, at least in the time that we've worked together so far, anytime that happens, I inform each of the board members, that an employee has been suspended, offer to answer any questions or take any phone calls about that, and then they proceed, or we proceed through the regular process of including any due process that might end up with the board having a hearing or making a final decision about employment. Thus far, knock on wood, we haven't had that with me and this board, but that would proceed following the due process law that's in place as well as our policies. Any other questions or concerns about D375? Okay, D475 is justifiable decrease in teaching positions, commonly referred to as RIFs.
The only request I had here, and it's in other places too, is anywhere where it says administrative guidelines, if we could have those shared as well. I know this is, in Neola's side, there was an administrative guidelines section that had those already built out. And so if we were going to start building the policy, are we going to change the administrative guidelines? And if we approve the policy in this case, we should at least be aware of what the administrative guidelines are.
Agreed, and we will continue to. We're going to get through the policies and then start working through the administrative guidelines and making sure that they reflect the same language in the new reorganized policies. So doing the same thing, reorganizing administrative guidelines, but under the structure of our current policy, or new policies. Anything else on D475? All right, thank you. Next one on the list is E150, programs for high ability students. And that one went from what was a very long policy under the Neola to a very short policy under E150, which is just a couple of sentences. Mr. Schultz, could you expand a little bit upon the concern that you shared? Help me understand that a little bit better. I think you're on mute.
Can you hear me now?
Yes.
I'm good. I looked up the administrative guidelines, so I'm good.
Oh, okay, thank you. Any other questions or concerns on E150?
Yeah, the only thing I had here was the statement, the Board of School Trustees shall develop a plan to provide appropriate educational experiences, and then a lot of other words. Do we develop the plan, or do we delegate the plan development to a group inside the school corporation and we approve the plan?
Go ahead, Mrs. Kazik.
Delegate, and the administration provides a plan that you adopt.
Okay, so could we have that worded?
Sure.
Thank you.
I find that interesting in the language, though, of a lot of the policies and even the law, where it says that the school board has the legal responsibility for some set of work that no school boards actually complete themselves. They approve and oversee.
We approve, right.
And so that's sometimes that's reflected in policy the same way that it is in Indiana code.
Right, exactly.
Thank you for that. Next one on the list is F250 investment, F200 investment income. Questions or concerns about that one? That one is unchanged, and it basically follows Indiana code word for word. Next on the list is F250 travel expenses. Also reflects Indiana code. The one change that is specific to BCSE is because of our unique situation with multiple high schools and lots of people traveling during the course of the school day, we made sure that this policy reflects our existing policy that says that if an employee is required to travel from one building to another during the school day as part of their schedule, we reimburse them mileage for that.
I had a couple questions, not really overly pertinent, just curiosity. For like going out for events, is there a specific mileage radius? Because like in military, it's usually 50 or 100 miles before we qualify for reimbursement. I wasn't sure if that was, and that doesn't really pertain to the school-to-school travel. That would be something like if we provided a corporate vehicle, I wasn't sure about that, so.
Outside of the county is the guideline that we have followed in BCSE before.
Okay. And the reason I asked that,
That may need to be in here,
yeah,
honestly,
that's why.
Maybe in your guideline.
in the administrative guideline.
The only other question I have is how often was that used, but I looked back through some of the priors and it's not very heavily used, so, yeah.
Okay, thank you. Next one on the list is G150, registered sex or violent offenders. Questions or concerns on that policy? Thank you. On a G250, pest control, there was a question about the requirement that we, and it does seem like an unusual requirement, that we maintain a registry of parents who are interested in receiving the notifications of pest control applications. And that is actually taken, copy and paste word for word from Indiana code as to what we are required to do when it comes to pest control applications. All right, next one is G300, latchkey programs, which in BCSE would be referred to as iCare. Any questions or concerns on G300?
The only thing I saw here was potential typo or grammar was adult to child ratio wasn't hyphenated. I don't know if that's necessarily important or not,
Thank you.
but.
Next on the list, G425, Pledge of Allegiance and Moment of Silence. That one's consistent with Indiana code and practice.
The only thing I had here was at the end, it says the flags of the United States and of Indiana shall be raised above each school. And at other places, flags shall be raised before, and there's a whole bunch of stuff there. It says that flags, there's another one somewhere that says the U.S. flag has to be put in every classroom as well. I think there's been lots of concerns with other flags of other types in rooms. I would like to see anywhere, whether it's in this policy or the other policies, state that the United States of America flag and the state of Indiana flag be the only two flags allowed to fly or be presented in a classroom outside of world history.
I think I understand where you're coming there from there, but my question is to the attorneys around other protections that policy may violate. Should we have any concerns there?
Yeah, I mean, that would likely impair a teacher's free speech rights to limit their ability to hang things in their classroom if it's not obscene or vulgar, so.
Just asking a question that was presented to me by parents, so be prepared if there's something that they don't appreciate.
Sure.
All right, any other questions on G425? Okay, next one on the list is G450, advertisements, publications, and naming rights. I believe that the question that was shared there is in regards to an appeal or a complaint about that. Is that right, Mr. Schultz, that it?
Yeah, I mean, can you hear me?
Yes.
Yeah, I think it set a different threshold. I think it said it ended at you versus, well, we had one about the principal and one at us. So as long as it refers to the same public process, I guess that's what however you want to word it. And the other one, the same concept here is what I was getting at.
Gotcha, thanks. We'll make sure it reflects that reference to the overall complaint policy. And then I wanted to note that we asked church to review this one after, it was just too late before we needed to have it posted on the website for everyone to review. Under the prohibited advertisements, publications, promotions, or sponsorship, we included I apologize, I'm looking at the wrong page. It's down on the next page. We added advocacy of or opposition to a political candidate, philosophy, or party. Basically just saying that our school grounds, vehicles, and facilities aren't the place for political candidate ads in the long list of other ads that are prohibited.
So I was wondering when I read that, that's not to replace the number 4?
Correct. Not to replace the number
It
4.
would be number 4 and everything else.
Everything else would shift out. Yeah, not eliminating any of the other,
Okay.
including number 4 on the one that's currently on the website, which is obscene and indecent and vulgar.
Just clarification on that draft wording labeled number 4. I wonder if it would make sense to repeat the word political in front of the word philosophy and party. I think that's what your intent was. Not advocacy of or opposition to a philosophy generally, but a political philosophy specifically. I think that's what you meant.
Yes, thank you. All right, next on the list, H-125, corporation support organizations. Any questions or concerns on that one? Okay, the last one then is H-175, questioning of students. This is a policy that we spent a whole lot of time talking about and working with, and actually have had a call with Mr. McIver as well as some other attorneys that we work with to conduct some training for our staff. You know, we've had our school resource officer relationship for a number of years, and you all just at the last meeting celebrated the longevity of the 2 original SROs that we had in Julie and Eric. But over time, as that relationship gets more comfortable, there is, you know, the possibility that you can rely on that relationship in decisions that we make, in that I trust you because I know you well, regardless if you're on the administrator side of that or you're on the school resource officer side of that. But the fact is that they're still law enforcement officers. And so we recognize the fact that we need to do some training with our administrators and our school resource officers together to make sure that our practice is aligned with law and with this policy, which is aligned with law. So we have that scheduled for October 7th at this point in time. And again, we're going to invite the school resource officers and even folks from the CPD and the Sheriff's Department, you know, so that we can all make sure we're hearing the same thing at the same time.
Are you going to include the 2 and 2 for East and North, the security officers that are not SROs, but they're supposed to be monitoring security at the front doors?
SSOs.
That's a good question. We'll talk about that and let you know. Probably not during that day because we want them in the building, but at another time would be the question as to whether or not we would conduct that for them at another time.
I mean, you could probably do all of them at once in a PD day.
Right. Thank you. Any other questions or concerns on H-175?
So, 4th paragraph, where it's talking about in general questioning or interviewing students on school property by a government agency is not allowed, and so on. There's nothing talking about parental consent in here. Does that need to be added? And the additional question to that is, maybe the line be with parental consent unless the parent is the basis of the accusation. Maybe it's a DV situation, or am I thinking too far into that? I think it's somewhere else in here where we kind of spell it out, but not specific to that paragraph. And it's trying to maintain consistency.
Thanks. We'll look at that unless you have something to add, Mrs. Koziski.
No. Are you asking about DCS questioning, or are you asking about law enforcement?
It's not, this particular is just a government agency. And so the way I read it, the way we start this policy, when I think government agency, I think anything not limited to all the massive amounts of law enforcement officers and how that fits into there. And it could even go in as far as military recruiters. I mean, they're part of a government agency. And so maybe parents don't necessarily want to have their child talking one-on-one with granted, there's a lot of times we don't allow that, but when you look at career days or something, there's potential for that. It's not necessarily one-on-one, but sometimes there are career fairs or will come in and meet and greets.
We'll look back through that and confirm that because there's a really valid point there around consistency even for our administrators to know that if someone shows up and wants to question a student, that we don't have to treat one agency when it comes to parent notification differently than we do another agency unless there's obviously a legal reason to. So we'll look back through there and make sure that language is consistent.
And then in the 7th paragraph, there's a repeat, which caused me to then go through every other, make sure I didn't miss any other typos. But it has of the investigation, and so it's repeating itself twice.
I see it. Thank you.
Little typo.
Thanks.
Yeah.
Any other questions on or concerns on H175?
And while you all pause, just so you know, Mr. Schultz did send me a message and said he had to drop off for work, so he didn't want you all to think he had just rudely abandoned you.
Well, thank you very much for your work this evening. We will have all of these addressed and ready to go for either their first reading on September 8th for that last group, or a second reading for the others. I also will share that the last package that we're waiting for, a handful of additional policies that we haven't received from Church Hill and Antrim, is a large package, but the good news there is that it will be the last package after we get through it. So it's going to be upwards of 25 or so policies on that last run, some of which probably will result in some questions and conversations, others will not. I look forward to your feedback about how this evening went, particularly in regards to the new policies, the ones that you had not seen yet before this last week, and whether or not you want to repeat that again, and that would be in probably late September, sometime around late September, to do a work session on those policies. So I look forward to that feedback. Thank you, everybody. This was the 14th day of school, and it was pointed out to me that before the end of the week, we will be 10% through the days of this school, the student days of this school year, which was just terrifying. Just terrifying. But
With the things that you're going to change or modify or tweak, could you, in the next posted draft or wherever the drafts are today, if you're going to change those, could you highlight the changes that are made? That way it's easier for us to just say, okay, I don't have to read all of it, I just have to read this section.
absolutely.
Thank you.
You're welcome. And I do want to take one chance to just thank everyone who's put an enormous amount of time into working our way through these policies. The church team and Mr. MacGyver, our cabinet that has read over and over these many times, and then Mrs. Chrisman and Mrs. Sandusky also in the background doing a tremendous amount of work. So trying to keep it as organized as possible. It's been a challenge, but I know that in the end, we will all know them better, and they'll be cleaner and more well organized. So thanks for the work.
We don't have to adjourn or anything.
We
right?
don't have to.
We just
No, we don't
get to
have to
go.
do anything.
Okay, let's just go.
Thank you again for setting up Rock Creek. I meant to reach out to you before I went to Wisconsin.